Good morning, everybody, and welcome to Macro Pro and Friends webinar series. We appreciate you being with us today. We're having a little bit of technical difficulties. I'm joined by Tiffany, Boyland, and Ryan Sapp, and as you could see, Ryan's camera is not working, so forgive us for the delay. So, Tiffany, how are you? How are things? It's been a while since I've actually seen you in person.
I know, it's so nice to see your face. It's always wonderful to see you. But yeah, I've been great. I was telling you yesterday, I have yet another animal. So now I have 3 dogs and 2 cats. So it's quite the adventure over here. But also I am approaching my 1-year anniversary with WC Law Corp as the managing attorney for Sacramento. And I'm very happy about that.
Oh, that's fantastic. Well, congratulations on that. Ryan, how long have you been with the firm?
I've been with the firm for about 14 months now. I practiced up in the Bay Area for about 15 years, and now I'm down in the San Diego area, and I'm now the managing attorney of the San Diego office.
Well, you certainly got a good place to relocate to, that's for sure. But do you also have 5 animals like Tiffany?
I have 6. I've got 3 dogs, 2 cats, and a bearded dragon.
Oh my goodness. Okay, so this bears asking our audience today, do you have 5 or more pets? I think somebody should let us know, because I think that sounds like a lot. You know?
I just love that somebody has more than me. That's wonderful.
Okay, well, before we get started, I want to tell people about another webinar that's coming up. This other webinar we're going to do is ask the applicant copy service any questions. You can ask the copy service also. We're going to be doing this webinar in October. So email me, Diane, D-I-A-N-N, at macropro.com with any questions that you want. We will have applicant copy services as well as defense. Any questions you have on the fee schedule, anything at all to do with copy work, please ask your questions. We're going to build the entire webinar around your questions. So today's webinar is worth 1 CEU credit. You've got to be logged on. So as long as I can see your name on the list of attendees, you will be receiving that. You should get that certificate in about 2 hours. If you have difficulty downloading it, please contact your IT department. It's usually a firewall issue. If you have any questions for our speakers today, please put them in the question box and I will ask them at the end of the presentation. And then there are handouts for today and they've done a great job. So be sure to download those so that you have it for future Yes, be sure to download those so you have them for future use. That's easy for someone else to say, but apparently not me. And then there's a few little forms in there from MacroPro, including one that could show you how you can reduce the number of pages that you're sending to QMEs. That's a big issue for you guys, so make sure you download those and get information on MacroPro's injury focus summaries. So Tiffany, I'm going to turn it over to you and Ryan.
All right, sounds good. Thank you, Diane. All right, so let me make sure that I'm doing this correctly. Yay! We were just joking before that technology is such a cool thing, but it's also just such a mess sometimes. So as we mentioned, Ryan and I both work for WC Law Corp. We're statewide and minority and female owned, and we're both very proud to work there. So at this point, Brian's going to kick off the presentation, and then we're going to kind of toggle back and forth. But go right ahead, Ryan.
Okay, so topics we're discussing today include procedure in general, including hearings, setting for trial, substantial evidence, as well as development of the record for those proceedings. Go ahead and go to the next slide. So I'll kick it off with expedited hearings. This is essentially, as everyone knows, a mini trial. Therefore, you have to be ready to go on the date of the expedited hearing, just like you would if it was a regular trial. That means that you have to have your witnesses and your evidence ready. And as an attorney, we always believe that it's best practices to bring 3 paper copies, 1 for yourself, 1 for applicant's counsel, and 1 for the judge, even though that you've already sent everything and e-filed everything. For past almost a year now, these have now been in person since COVID. The only exception is if you can successfully petition, usually with the agreement of opposing counsel, to have them done remotely in exceptional cases, but usually the judges are requiring you to go in now. Expedited hearings are only for cases that are accepted. If it's the denied case, then the proper procedure is to go through a priority conference or MSC, as well as trial before expedited issues can be heard. Generally, the issues to be heard at an expedited hearing include entitlement to medical treatment, whether an employee is required to obtain treatment within an MPN, medical treatment appointment or medical legal examination, so your panel QME disputes are subject to the expedited hearing procedure, as well as applicants' entitlement to the amount of temporary disability indemnity. Finally, an employee or an applicant's entitlement to compensation from one or more responsible employers, where the two employers or carriers are disputing the liability among themselves. That could be subject to the hearing as well. Next slide. All right, here's kind of an important topic, is the petition for automatic reassignment of trial or expedited hearing to another judge. Each party is given this right, and it's an automatic reassignment depending on how it occurs. Both the applicant attorney is entitled to a strike of a judge, as well as a defense, the defense side. Some things to take away from that is that if the first notice of the trial is while you're at an MSC, back when this was in person, what you would do is you'd make an oral motion to be acted upon by the presiding judge. In practice, at least in my experience up in the Bay Area when we were in person, was that you would fill out the pretrial conference statement, and then you would take it to the clerk, and the clerk would give you a date, and then both sides would tell you who the judge was after you confirmed the date, and then you would just either exercise your right to strike that judge or not, and then the other side is given that opportunity as well, and then they would just give you another date based on another judge. The other procedure is if you get the notice via mail through a notice of hearing, you have to act upon that within 5 days of receipt of the notice of hearing. That can be done by a petition, and we have a copy of that in one of the next slides. But the important takeaway from that is that you can't sit on those. You have to immediately act on them within 5 days. If it is granted, usually you're given a new trial date for either a trial or expedited hearing. And another takeaway is if you're in one of these smaller jurisdictions where there's only one judge, then this will be ruled upon by a deputy commissioner of the appeals board. Now, one of the takeaways that I always mention on this is that, say you have a temporary disability dispute, but you're going to resolve it, and you know it's not going to proceed with the expedited hearing, but you get the notice of hearing for expedited trial in the mail, and you have an issue with the judge that's assigned. In order to preserve your strike, you still need to strike the judge through the automatic petition. Otherwise, you can be stuck with that judge for the remainder of the life of the claim. So even if you know that it's not going to proceed to the expedited hearing and it's going to resolve and you're just going to take it off calendar, still file that petition because it preserves your strike moving forward, and you will not be stuck with that judge moving forward in the case. All right, go ahead and go to the next slide. All right, so yeah, this is basically what I just said. If you don't strike, you will be stuck with that judge for the entirety of the case. So it's very important to do it. Now this is not my, oh wait, back on the old slide.
Sorry.
Okay. Some jurisdictions handle it differently. The second point here, I haven't experienced this myself, but well, actually recently when I did file a petition to strike a judge on an expedited that I knew was going to go off calendar, but they did not act upon it because I guess at the Los Angeles board, their procedure is for you to show up and try to resolve any issues before they send you over to the presiding judge to send you, give you a new judge. So you would actually have to show up on the day of the expedited hearing if we weren't going to go OTOC. But again, because I did file my petition to strike, I preserve my right going forward on any other trial or hearing that gets set. So go ahead, next slide.
I am trying, 1 second. It's, there we go.
All right, procedurally, again, once you fill out the pretrial conference statement and you submit it to the judge, this says he or she will give you the trial judge, but again, in my experience, it was always the clerk. More recently, when
it's a mix of it up here. And it can be a little awkward sometimes to strike a judge in front of a PJ or another judge, but it's a mixed bag. Of sometimes they'll send you to the window, sometimes they'll do it in person, or at the hearing now over the phone. But nowadays, even over the phone, oftentimes they'll send you to the calendar clerk, which makes it a little bit less awkward.
Yeah, since we've been doing it over the phone, sometimes the judge will give you a date, and then you hear who the judge is, and then they'll ask if you have a strike. Now, the tip that Aaron and I have talked about in our prior presentations of this topic is that a good tip is to just wait to see if the other side challenges the judge first, because you may both have issues with the judge that gets assigned, and rather than use your strike right away, allow the applicant attorney or the other side to exercise their right first, so that then you have a chance at a second strike. Again, after you do the challenge, you'll be given a second judge, and then the other side is given the opportunity to do the same. Now, if you have a hearing representative at the trial or MSC that's setting for trial, it's always a good idea to have somebody, an attorney that's familiar with the venue on standby, so that you can call them and get some advice as to whether or not you should strike the judge or not. Same goes when you get a notice of expedited hearing. Again, you have 5 days to act. Call one of us or call an attorney that you know is familiar with the venue to get some input rather than sitting on it. The next slide is the example petition for automatic reassignment. And it's pretty boilerplate. It's an automatic strike, and so as long as you fill in the information and file it timely, you should have a reassignment automatically. All right, the pretrial conference statement. We're getting to the meat of the presentation here. What you want to do is when you fill out the pretrial conference statement, you want to fill it out as best as you can. And my procedure is always, as part of my preparation for an MSC, is to always prepare the pretrial conference statement a few days ahead of the actual hearing. What you want to do is review the entire file and make sure that you have identified what you have an agreement with the other side with, as well as what your issues for the trial are, and finally your evidence and witnesses. Your stipulations are things you agree to. However, you should always be careful as to what you're going to agree to. For example, occupational numbers, the average weekly wage, because these are stipulations that you could be bound by. Applicants' attorneys will oftentimes try to get you to agree to more than you need to. If there's a dispute or any question as to any of these issues, do not list it in the stipulations, but leave it for one of the issues pages. In terms of the issues, again, these are the issues that will be heard for trial: permanent disability apportionment, future medical care, as well as writing in any affirmative or threshold issues, for example, statute of limitations, good faith personal actions, and any other defense that you have on an affirmative basis. You want to be as specific as possible so that there's no question as to whether or not you raised the issue at the MSC to be heard at the trial. Then you're going to list your evidence and your witnesses. And again, I think another slide covers this, but the way this works is you'll fill it out, and then the other side will look at it, and then once you have an agreement, you'll go before the judge and usually have a discussion with it, and then the documents will be signed, and then a judge will advise you how they want it, or how they want to receive it, either via email or you e-file them, or if it's their preference, they'll do both. All right, so we have an example pretrial conference statement in the following slides. It's also known as the 5-pager or the steps and issue page. The rules that some judges have you do it on the day of the MSC, and then it needs to be ready by the time they call your case. However, some judges have more relaxed rules, such as, do you need to have a discussion with the judge on these issues? But again, a best practice, at least from an attorney standpoint, is to have it filled out as much as possible prior to the hearing. And really,
I couldn't agree more, because especially if you get a certain judge, they'll boot you off the call immediately if you're not ready to go. They'll just take you off calendar. It's getting a little bit better during like the peak pandemic. I don't know if it just made people angry or what, but that happened a lot more than it does now. But and also just in the interest of being prepared, but I would still, for that reason, also have this ready to go.
Yeah, and then on the flip side, you have some judges who will tell you that, okay, we're going to set for trial, submit the 5-pager within the next 5 business days, and we'll assign you.
Exactly,
So
yeah.
it does vary, but again, best practice, fill it out as much as you can ahead of the hearing. When you're at an expedited hearing, this pretrial conference statement will be, it'll be prepared on the date of the expedited hearing before the judge, and you'll have an opportunity to discuss with the other side and the judge what the issues are. All right, we'll move on to our example 5-pager. This is a trial that I took to trial up in Oakland. You see that there's a lot of scribbling handwriting from the Honorable Judge Russell from Oakland. He frames the issues and tells you what his take is on it, as well as any rulings in terms of discovery orders and proceeding with the exhibits. So this is the front page that kind of gives the general information and also counts as a notice of hearing for the trial as well. The next page is the stipulations page. Now, this case went to trial over a dispute between a panel QME and a treating physician. Applicant's counsel and I had an agreement as to what the rating was of the panel QME, who had evaluated the applicant on 3 occasions and had been deposed twice, but at the last minute, after his last deposition, he let his panel QME license go. And so applicant's attorney deposed the treating physician and then argued that despite the treating physician reviewing nothing new, that she was entitled to another deposition of the panel QME and therefore was prevented from doing so because the panel QME no longer has a license. So of course I argued we had already spent thousands of dollars on discovery. There was no new information. This is all a review of records. No new information was brought to light in the PTP deposition. It was just doctor shopping on the side of the applicant's counsel. And so we listed out the issues as we saw them. We didn't include an occupational number because, again, it was either a 0% permanent disability based on the panel QME, because it was only a temporary issue of the applicant's condition that returned to baseline, versus the PTP, who said that she needed further treatment in the form of a total knee replacement. So we left out some the occupational code because, again, we had the agreement. But we did list out everything that had been paid on the case, including the permanent disability that had issued before the panel had issued his final opinion. The next page is the issues. And here again, I listed my defenses of closure of discovery, the claim for replacement panel by the applicant's attorney, as well as claiming overpayment of permanent disability, since again, our panel QME ultimately decided that there was no permanent impairment on the case. And then the next page is where the judge will take his or her notes. And here Judge Russell, essentially, it was a good MSC because Judge Russell kind of looked at the other side and was like, so you're doctor shopping, right? And so nice. he really framed the issue for the trial judge. And it's kind of sloppy handwriting, but it all boils down to that, whether or not the applicant's attorney was entitled to a replacement panel. And he noted what our arguments were in terms of the amount of discovery we had performed with the panel at the time. So here the judge will try to frame the issues for the trial judge. And often, when a MSC judge holds open discovery at the discretion of the trial judge, this is where they'll write their comments saying, well, I'll let discovery to be open, but I'll defer to whether or not it's admissible to the trial judge. And this is letting the trial judge know that that's an issue.
This is really interesting because half the time this page is just blank, disservice.
Right, right. Well, Judge Russell is very detailed, and he does write long comments on his, and even his minutes of hearing are pretty long as well. I think he likes to use his prior minutes of hearing as part of his prep for next hearings, and so it's actually a pretty good practice, and I actually appreciate it. Again, now once the judge has written these things, you do want to make sure that you've reviewed them before you sign the documents, because he may say something that you don't agree with, and you may want to raise that as an issue on your issues page if the judge brings something up. So that's another thing to keep in mind prior to final submission of the pretrial conference statement, is to always make sure that you know what's going in there by the comments by the judge. And the next page is where you list your witnesses and exhibits. Here, this was again an over the phone MSC, and the judge just had us both write down what our exhibits were. So I listed all my evidence, including the important excerpts of subpoenaed records, as well as the deposition transcripts and benefit printout, and then applicant's attorney just listed reports and deposition transcript to the PTP. And it's okay to say various on these things, especially with the PTP, because PTP reports are always admissible. But with anything else, with the exception of subpoenaed records, you do want to be pretty specific as to your description of what you're going to file. I always, as a practice, at the bottom of my list is always to list all listed by applicant. Therefore, if they, listed something in their exhibit list and then didn't submit it, you can always bring it in, as well as use their exhibits against them if it actually helps you in your mind. So again, normally you have 20 days before trial to submit them. And again, this is so that there's no surprise to the other side as to what you're going to submit for trial. And then next page. Now this is an extra page, and this is usually used only if there's additional cases or parties where it clearly lays out what the dates of injuries, what the issues, or what the parts of body and each carrier or defendant is involved. I believe with that, we go to Tiffany.
Okay, so I'm going to be covering in this section what the issues are, what you want to list, and what to be careful about, essentially. So as kind of alluded to earlier, you have a duty at the MSC to raise all issues that need to be heard at trial. So oftentimes at MSC, they'll argue out the issues with the judge, and the judge may try and limit the issues or try to even resolve an issue so that essentially so that the 5-pager is as succinct as possible, and that the trial judge has, I'm not trying to phrase it as little to do as possible, but just so that we're being efficient. So, but they will oftentimes also defer to the trier of fact. I've seen that happen more often than not lately. But they may try and resolve some issues at the hearing. I suspect it's because they don't want to have to create a record if they were to make a ruling on whether or not something would go to the trier of fact, but they will make some effort to limit issues. And so you're going to have to make your arguments and try and keep your issues in that are important to you. But generally speaking, a judge isn't going to hear an issue that wasn't raised at the 5-pager at trial, because it would deny the other side due process. So failing to do so may constitute waiver and prevent the other side from, or preventing that party from raising the issue at trial. We'll go over exceptions, of course, but the idea is that this isn't, as I like to joke, law and order, like we can't surprise the other side. And actually you can't do that in that arena either, really, but they like to do that on TV, but we can't show up with gotcha evidence or information at trial and say, aha, we win. So, and it's also helpful on our side if applicant's attorney were to show up with something that we weren't expecting, or retain a new report, which we'll go over in a little bit as well. But so it works for our side as well too. And sometimes these issues, especially affirmative defenses, may not have come up before for some reason, and it's going to be difficult to try and assert them at the time of trial if you didn't know about them before. That said, and we'll go over this a little bit more thoroughly too, but you can, of course, always agree jointly to add an issue to the pretrial conference statement. There might be something that you just neglected to put on, or a typographical error, that type of thing, the wrong group code, and both sides are like, oh yeah, sure, let's just clear that up and fix it, and the judge will be happy to do that. But yeah, you're just trying to make sure your PCCS is as accurate as possible so that you don't have issues when you're at trial. And this last point here is that a judge can raise an issue on their own will or motion. Sua sponte is one of my favorite phrases for some reason. I just love the way it sounds. And I suggest it to judges all the time for 5813 petition. Instead of doing a petition, I'll say the judge is invited to raise this issue sua sponte, but it is something the judge can bring up and may bring up at the trial setting, because as you'll see in later slides, there is going to be a discussion before you go on the record and submit your matter. So what happens if you did forget to list something at the MSC and need to raise it at trial? So the regulations state that pleading shall be deemed amended to conform with stipulations and statement of issues agreed to by the parties on the record. And that also provides that the pleadings can be amended by the Workers' Compensation Appeals Board in order to conform to proof. So if there's something that's in error and conflicting with the proof that's been presented, they can fix that. So the parties may also make changes, of course, as alluded to earlier in the stipulations on the pretrial conference statement, and he can also agree to adjudicate new issues. So something has come up since sometimes it's months before you get to trial. Could be a few weeks, depends, but sometimes it's months, and maybe something else has arisen that one side or another really feels needs to be added as an issue, and perhaps you don't have a problem with that, or you'd like to be efficient and get that done as well. So whatever ends up happening at the trial in terms of stipulations and issues is going to supersede the original 5-pager. So that's going to be what's locked in. And at that time, the judge is going to assess any prejudice the opposing party might have in deciding whether or not an issue that wasn't raised at the hearing could be raised at trial, meaning that that's part of their analysis as to whether or not to let a new issue in at the trial date. So that's going to be part of your argument as well if you're on that side. So we're going to go through another 5-pager. So in this one, this is just the first page, just lists the caption up at the top, up here. You're going to list the applicant, the defendant, the case number, who you're appearing in front of at the MSC, and then just list appearances. And then, as you probably saw before, and you'll see again in a little bit in the disposition box, that's going to have all the trial information in terms of the amount of time you've been given, allotted, and the date and the judge you're going to be in front of. And this is important too, because the amount of time you're allotted can really vary, and depending on your issues. And a lot of times, if there's several issues, it's really best to err on the side of caution and get a half day or a full day, because something always goes wrong. The court reporter can't get their thing to work or whatever, something always goes wrong. So as alluded to earlier, this is a stipulations page. And so as Brian was talking about, like, so there's a group number listed on this one. So that is something that if we agree upon, that's going to be listed there. When I fill mine out, I go ahead and put the occupational number that I want, and then give it to applicant's attorney for their review. And if at that time they make a counterpoint, or they think it's a different number, then it'll end up on the issues page. But I try and get it in there, just like they try and get stuff in there, and just keep things moving and get the number I want. And then let's see, this was a heart attack claim, it looks like. And here's the PTP down here. No attorney's fees have been provided for. We almost always select some medical treatment, because even on denied cases, we usually have provided something before it got denied. So that's usually pretty common. And then if you can list what either EDD has paid or you've paid, particularly if there's some sort of issue with temporary disability rate or what they're owed. So again, issues listed are, in this particular case, AOE, COE. So that's really important to check off. They're checking off permanent and stationary, most likely to deal with a temporary disability issue, because it looks like EDD paid out, and they paid out quite a bit. So that's going to be a significant issue for a potential differential owed to the applicant. And then there's the affirmative defenses listed as well. So anything not listed in the checkoff form, or where you can write things in at the bottom, you just write in other issues, and you can elaborate. You can even sort of make your argument, like make your position. It's not time for a trial brief in this portion, but you can list your defenses. And Brian, if you know anything about this case in particular, I know that the other one was personal to Aaron. I know about that one, but if there's something I'm forgetting, just let me know, of course. But so yeah, then this is the exhibit page. This is defendant's exhibit. We do sometimes do joint exhibits. I have had 2 trials recently where we literally just couldn't find the applicant, couldn't get a hold of them to sign any paperwork. And so we just submitted. I actually recently did a trial over the phone. It took about 6 minutes. But because the issues were pretty much all stipulated to. I mean, even the PD was stipulated to. So our exhibits were joint, and it was really just the QME reports and things like that. So, but if you have arguments to make like we do in this one with statute of limitations, you're going to want your exhibits to be your exhibits and not applicants. And then when you go to trial, they'll narrow it down as to which ones are duplicative. But because this is a let's see, it was statute of limitations, so they've got a personnel file in there as well. That's not something you would always put down, but in certain cases you would for sure. And then we have applicant and all applicants' witnesses. And it's always good to list their deposition too for rebuttal purposes, because you can use that to impeach them, even though the judge isn't going to review the entire deposition necessarily. Okay, so Labor Code section 5502, sub D, sub 3. Discovery is supposed to close at the mandatory settlement conference. It's why we file DORs. It's why both sides file DORs to cut off discovery and get to the board so that we can't develop the record more and get more favorable evidence. But that doesn't mean that once you get there, that might not be a problem for the MSC judge and the trial judge. And we'll elaborate on that in just a little bit. So evidence not disclosed or obtained thereafter shall not be admissible unless the proponent of the evidence can demonstrate that it was not available or could not have been discovered by the exercise of due diligence prior to the MSC. And it's I would say, generally speaking, a pretty high standard, but it does happen sometimes that something pops up that you just didn't have before. But you're really supposed to have not gotten to that point if that's the case. So, okay, so what can you list, excuse me, as evidence? So any judge, any decision a judge issues has to be supported by substantial evidence, and in particular, substantial medical evidence, as well as, of course, the law as well. So you want medical reports that show that. You want them to have reasonable medical probability, germane facts, adequate medical histories, adequate examinations, correct legal theories, not based on any type of speculation, and the physician needs to really set forth their opinions and as to why, and not be conclusory in nature, period. And what I see a lot of, and Ryan can probably speak to this too, is you see a lot of the magic words. They'll put all this language in the report and then just jump to a conclusion and not give you that how and why that you need so much to show how they got to that opinion, and of course why they got to that opinion and what that was based on, what information they used to get to that point. So, and one of the ways they do that is by taking an adequate history and adequate examination. I haven't seen it as much lately, but earlier days of my practice, we had kind of a rash of applicants telling us that the QME had examined them for 15 minutes and then booted them out the door. And then they noticed on the report that we got billed for 2 hours, 3 hours, 4 hours, whatever it was. And those doctors were, that got handled. So it doesn't really seem to happen as much anymore. But that's an example of what you're looking for, is an adequate examination where they actually did what they were supposed to do. So.
Yeah, this comes up a lot in terms of the actual reports. This is the meat of evaluating the panel QME reports for substantial evidence. You really need to, they can't just use the magic words that this is based on reasonable medical probability, but not give you the how or why. They need to spend a few paragraphs on why they reached the conclusions that they did, not just simply state that they did.
And it's so helpful too, just in terms of practice, because if I get a well-written report and it's not a bunch of, just conjecture and sometimes it almost feels feelings-based, some of their opinions, but I know whether or not I'm going to have a shot in depo of changing their opinion, or whether or not the judge is going to need more development of the record, that type of thing. So if you get a well-written report, I mean, a lot of it, you're done. You don't even have to go to trial. Sometimes you just can go forward with settlement, which is always a nice goal to have as well. Okay, so developing the record, when this does happen, the preferred method for doing so is to allow the medical record to be added to or supplemented by the physicians that have already participated in the claim, including the existing QMEs to the extent possible. The issue there is that sometimes their reporting is so deficient and has been historically so deficient that it would be useless to go back to them, and they've already demonstrated that they can't do their job for us. So in that event, the judge is going to encourage the use of an AME so that the parties can get a better, more substantial report. In the event that they can't do that, as often happens, then he's going to send you to a doctor that they choose, an IME, independent medical examiner, which, you know, kind of sometimes is what you need in certain cases. Sometimes these reports are so bad that even when you depose them, it's so bad that you need to turn elsewhere to get the case done. And then let's see. Okay, so limitations, this is an example. So this applicant's attorney tried to enter a medical report at trial that he had not disclosed at MSC and gave no explanation as to why. So the issue there, though, that still comes up is whether or not the judge still has to develop the record. Like, is this report going to be so like of so much assistance or clear things up so much that we were best to add it in? And so here we have the board's power to develop the record cannot be used to circumvent the clear intended language of the section 5502 sub D sub 3, which is a slide a few back that I went over, meaning that this discovery is supposed to close at the time of MSC unless it was something that could not have been discovered with due diligence. So, and I believe we're kicking it back over to you at this point, Ryan.
Okay, so again, the general rule is that if a party fails to disclose either a witness or an exhibit in the pretrial conference statement, that evidence is inadmissible, and this can have significant negative implications in the case. The most glaring example is that you have a denied case, but you failed to list the denial letter. This could result in a presumption of compensability in the case. So the parties, you need to be careful as to what evidence and witnesses that you list at the MSC. However, if there is insufficient evidence presented to the trial judge to decide an issue, the judge may develop the record by taking further evidence as they feel necessary. For example, when one side presents a report that is either unreadable or illogical, or it leaves out vital facts or does not gather evidence needed before the MSC, it could the judge may just simply rule that, well, based on this report, I can't rule on the issue, and can again go back to the last slide, send you back to those options of either a going back to that evaluator for supplemental commenting, push you towards an AME or an independent medical reviewer. A judge can also ultimately determine at the end of the trial that there's no basis for which they can make a decision and believe that more evidence must be gathered and set out an opinion as to that as well. Another ruling that a judge can do is based on a change in law or interpretation of law. If there's a new ruling from the recon unit or appeals board, the judge may simply tell the parties that you need to further develop the record as to that issue as well. Finally, and this is kind of the catch-all, they can further develop the record when it is needed to serve substantial justice. Now, that general rule of not listing a witness or evidence on a pretrial conference statement can be waived if the parties simply agree to it. The parties agree that, oh, you know what, we forgot to list an important key piece of evidence that the judge actually needs to make a ruling on the issue. The parties can stipulate to having it come in. And again, as Tiffany said earlier, the pretrial conference statement you can't be bound by, but really at the time of the trial is when they read in all the evidence and what the issues are. And so if the parties have an agreement that a witness or a piece of evidence that was not listed needs to come in, at that time the judge can simply allow it in by agreement of the parties. Parties can also agree to keep discovery open following an MSC, assuming the judge allows it. Again, these are cases where you've objected to the DOR and you've set the panel QME's deposition. This is just an example. You've set the QME's deposition, but the judge says, well, we can set it for trial and allow for the deposition to occur before the trial occurs. And that's leaving the discovery open while pending the trial. The judge can also permit discovery to be kept open following an MSC when surprise evidence is introduced. And this has occurred on occasion when sub rosa is disclosed on the day of the MSC. At times the judge will say, well, that the evaluators need to look at this if it's key. So they'll keep discovery open for that issue. Judges can also close discovery, but allow it to remain open for specific evidence on one particular issue. Again, the example that I gave previously is on point for that. Pro pers. So the judges are always pretty protective of unrepresented applicants, and so they usually are willing to bend some of these rules to accommodate a pro per. Generally, yeah.
That's my experience.
Yeah, this happens 100% of the time. They will allow some leeway for an unrepresented applicant. However, a judge cannot simply exercise the duty to develop the record if doing so would unfairly reward a party who did not, without the use of due diligence or through their own negligence, where they're unable to meet their burden of proof. So just because the other side has a terrible attorney, the judge cannot exercise his right to develop the record if they simply didn't do their job. Evidence not disclosed to the MSC may not be admitted simply because the opposing party would not be prejudiced by the admission. An attorney's inadvertence or neglect to introduce evidence will not justify admission of the evidence after trial either. Again, if you failed to list something that's important and you didn't introduce it at the time of the trial as a supplement, you can't later go back to the judge and try to add something after the trial's completed.
Put that in your recon, you're gonna get smacked. So it's not gonna work.
Exactly. The incompetence of attorney, again, not good cause for further development of the record, as well as a change of attorneys is not a valid reason to further develop the record either. If the judge is willing to let in a piece of evidence from the other side and you have an issue with it, you need to make sure that you object to that evidence at the time of trial, and you need to make sure that that objection is placed on the record. So once the trial starts and they start reading in the evidence, and the judge is going to allow something that wasn't listed on the MSC statement or the pretrial conference statement, you need to make your objection on the record. And just as the judge usually reads in the evidence, they'll ask if there's any objections, and that's your time to lodge your objection to the introduction of this new evidence. And that's just preserving your right on recon. All right, evidence obtained after the MSC. So this often comes up in the issue of surveillance of the applicant. There is a stricter standard for the admissibility of this evidence obtained after the MSC. And there are, while the courts are suspect as to evidence after the MSC, there are several cases that actually have allowed it in. The proponent of that evidence must demonstrate why it was not available and could not have been obtained with the exercise of due diligence before the MSC. So basically, diligence and good faith are required for both sides. And again, an example of this, and this always comes up as a question, I've done this presentation a couple of times now, and basically you need to show, especially on surveillance evidence, that you've been attempting to get surveillance on the applicant throughout the case on multiple occasions, and you just haven't been able to get anything. But after the MSC, because you've been able to demonstrate that you have an ongoing investigation of the applicant that wasn't complete and was ongoing, and then you finally found something after the MSC that is beneficial for your side, that weighs more in your favor. It's not a guarantee that it'll come in, but it goes towards your due diligence and good faith attempts at obtaining the evidence prior to the MSC. Next one. All right. If you failed to list the evidence in the pretrial conference statement and you want to use it at trial, you can also bring in the evidence through various issues, mainly to impeach the witness on the stand. Evidence could be admitted after an MSC in order to rebut unanticipated testimony. And there's the case there, I don't know how to pronounce that, Kuykendall.
I was gonna let you know it. I don't remember how to say it. I remember it's an SIPTF case, but that's about it. Yeah.
So unanticipated testimony never came. So this would be testimony the applicant testifies to something that is either contrary to what he testified to in deposition or reported to the evaluators or his treaters, and that therefore is unanticipated, and you have some evidence that rebuts that. that's a way to admit that evidence and bring it up at trial. Surveillance, again, after the MSC, is allowed to rebut or impeach applicant's trial testimony. However, the testimony must be surprising or unanticipated in order for the appeals board to exercise its power to further develop the record to admit that evidence. If the testimony could have been anticipated, you will not be allowed to present undisclosed impeachment evidence.
There we go. All right, back to me. All right, so filing evidence pursuant to Rule 10620. Excuse me, my allergies are kicking my butt today. Any document that a party proposes to offer into evidence at trial needs to be filed with the WCAB at least 20 days prior to the trial, unless otherwise ordered by the WCAB. I just had one that was 10 days. It was a very simple trial, so we just did 10 days. But the trial judge, of course, still has discretion to allow things in, even if this does not always happen. And we're going to give you an example, a real life example. Okay, so in this particular case, there was a panel dispute, and I'll go into the details of that in just a little bit. But applicant's attorney listed evidence for trial, but then didn't serve it 20 days prior to trial, and instead filed it the morning of the trial. And as you'll see, some of the evidence included excerpts and like various type of evidence. So that's a little bit concerning. So defendant objected to this, obviously being entered into evidence, and the judge overruled, stating that the evidence was listed with specificity and that there was no surprise to the defendant in allowing it. And we'll go over why that was in greater detail. But as you see from the prior slides back here, it has to be something surprising. And essentially, again, the law and order, joke, like we can't surprise each other. It has to be, we're not supposed to be doing that. So in this particular case, as you'll see, it was something that we already had. So again, just quickly, this first page is going to tell you that we're doing a half-day trial, and then the parties have reviewed the pretrial conference statement and agree it's joint. Parties are to file and serve. This one says at least 10 days before trial. So, and then we have the stipulations up here, relatively brief, because the issue again is really not so much about, like, we're not submitting for a permanent disability award, that type of thing at this point. So again, it's kind of hard to read, but essentially applicant is contending that the defendant obtained a panel number inappropriately by not including what their preference was correctly to the medical unit. And then let's see, so then here, just as an example again, so this is Judge Aldrich. She's great in Sacramento, but this is a little bit shorter pretrial conference statement discussion from the judge. She's just noting service, and then up here she's noting dispute regarding QME panel, denied claim, no QME evaluation. So just a short little concise thing for the trial judge to look at. And then so here's defendant's exhibits. And we did list correspondence between applicant's attorney and defense attorney. That may have been part of the reason why we were overruled. But so we've listed that, as well as the panelist denial notice, anything relevant to trying to prove up that our panel is valid. I did want to point out before I forget too, in terms of witnesses, you can obviously just list applicant, but if you do have employer witnesses, you need to also list that with specificity. You can't just write HR manager, you need to write Judy Smith, HR manager, or whatever their title is. And then let's see. Okay, so here's what applicant filed. And so as you can see that from the little blurb over here, this was all in defendant's possession because it was correspondence between the parties. So nothing that to catch us off guard or that we didn't already know about. So it was a good argument to make. You have to make your pitch. I think the applicant attorney should not have done this, and hopefully he or she was admonished. But this was all in our possession, so it wasn't prejudicial to us really. All right. So what happened? Go ahead, yeah, please.
The only thing I would add, I don't know if you're going to cover it, but I don't think you are. And if you do have non-party witnesses that you have, you need to subpoena them for the trial.
Oh, I was going to say that next.
Okay, good. Okay, never mind. Then I'll let you know.
Fine. Go ahead. It's fine. Go ahead.
Okay, yes. So you do need to subpoena them, and this includes for expedited hearings as well. That way, if they, for any reason, if their car breaks down or that there's some kind of family emergency, it does preserve their testimony, and the judge will find good cause to allow the testimony at a subsequent hearing. If it's a friendly witness, you don't have to have them personally served. You can do a self-executing service where they acknowledge receipt and notice of it, and so that's less burdensome than going through a service processor as well.
My
But anyway,
personal preference is a regular subpoena, regardless of how friendly they are, just because it lends more credence to the judge letting me get a continuance if I need it. But it's client preference. It's it's your preference as well too. All right, let's see. All right, so what the heck happens at a trial? You think we just like sit around and eat popcorn and tell stories? Because we do. No, I'm just joking. So anyway. Well, not the popcorn part at least. But anyway, so as Ryan mentioned earlier, all trials and expedites are now in person. It's really depending, I wouldn't even say it's board specific, I'd say it's very judge specific as to whether or not you can get a virtual trial still these days. There are definitely some applicants attorneys out there that try to file at the last minute for an expedited, and that doesn't go over too well in my venues. But yeah, you can jointly request or even unilaterally request for whatever reason. Usually, normally I see health reasons, but sometimes it's availability of the applicant or their ability to travel to the board, that type of thing. But so anyway, as we alluded to earlier, there's first going to be discussion off the record at the MSC, and then you're also going to have an off the record discussion with the trial judge before you start the actual trial. And here again, very similar to the MSC, you're going to be limiting your issues and correcting anything that needs to be corrected, stipulations, exhibits, that type of thing. And so all of that's going to happen before the formal setting takes place of a trial. Once that's done, the judge will call on the court reporter. Call on the court reporter. They'll start the record, and generally speaking, the judge just goes through the 5-pager and lists all of those stipulations and all those issues on the record. And each party, as you can see here, gets a chance to object or agree to both. And that does happen because even though you just went over it, maybe the judge misstates something, or there's something's mispronounced, or whatever needs to be corrected sometimes. And it may be something more substantial than that as well too. So it's also on the record, the judge is going to go over all of the exhibits, so all the things we just went over, documents, correspondence, medicals, and list them out and assign them letters or numbers depending on the judge. And here again, each side will get a chance to object or agree, which is important, especially like we discussed before. If you have an impro perm, they show up with a ton of stuff that you've never seen, or what have you. So then at this point, you're going to call in your witnesses. They're going to be sworn in. Applicant goes first, direct examination by his attorney, and then cross by the defendant. And then the applicant's attorney might go back and redirect to try and clarify anything that came up in cross-examination. And then they're going to call the rest of their witnesses. And then that's going to be followed by our witnesses. And then applicant's attorney, of course, gets a chance to cross-ex at that time. And as you saw even from the 5-pager, the judge is also going to be at trial taking down a lot of notes. So give them some grace, and as people say these days, and give them, slow down a little bit, which is not easy for me because, as you know, I'm a speed talker, most of you, anyone that knows me. But I've very often been told by a court reporter to slow my roll. But so do your best to let them get their notes down and everything too, because I found sometimes that they almost rely on that more, it seems like anyway, than the actual word for word record. And I think it's probably because they're having their first impressions as they're taking notes. After all that's done, the judge is going to ask both parties if everybody's ready to submit it, and which means you're done. We're going to make a final record and make a decision. So if there's anything that needs to come up, that's when it needs to come up at that point. And then it's submitted by the judge for decision. And then at that point, as you see from the last little point, the judge will either make a decision or they'll decide that they need to develop the record, as we kind of covered earlier. So it looks like, yeah. So there's our information as well. You're always welcome to email us questions. Probably many of you have our cell phones too, that's fine as well. So if you don't have any now, or you can't think of anything, or you do later, just please know you can always email us. But so let's get Diane back on, I guess, or Ryan, do you have something?
Yeah, I just wanted to add just some best practices tips here,
Please, go ahead.
especially when preparing the 5-pager. So like I mentioned before, best practice is always to prepare the 5-pager before the MSC. And I know a lot of you here are actual claims professionals, and you have attorneys and, that you're working with. And my practice, especially when you know something is going to be going to trial, is not only prepare the 5-pager, but also send it to your client as well to look over, so that you guys can work in tandem in terms of what the issues are, how you're framing them, and make sure that all the evidence that you have identified match with what your the claims examiner also has. And oftentimes they'll bring something up, or you'll bring something up that they had forgotten. So it's just good to always keep that communication going, so that there's no surprises and you're all on the same page.
It's a great idea.
Yep, outstanding. Well, you guys did a great job. You couldn't tell there were any technical difficulties. Sorry,
Other than
Brian,
not seeing my pretty face.
I wanted to let you know, Tiffany, there is somebody here with 3 dogs and 3 rabbits and some cats. She's got 3 dogs, cats, and a couple rabbits. So you are not a crazy cat lady or anything like that. Well, we want to thank all of you again for coming. I just want to remind you about upcoming webinars. Tomorrow we have one on identifying and managing high exposure claims. That'll be at 10 o'clock. Make sure you register at macropro.com. We will also have a year-end review for Medicare, or mid-year review for Medicare. And then we have overpayments for TD, you know, how to administrate them, how to recoup them, and then of course how to prevent them at all from happening. And then we have our next 2 of the 3-part series of COPS and claims, mental health claims. That was fantastic yesterday. If you guys had an opportunity to see, it was a police officer that you could tell that even though he's retired, when he tells these stories of things that he sees and what his brothers and sisters have seen, he gets very choked up. And I think everybody should hear these, because at one time, even if you don't handle those claims now, you may handle them in the future. Outstanding. And then lastly, please remember to email me, Diane, DIANN, at macropro.com with any questions you have for any applicant copy service or for defense copy service, and any questions you might have on the fee schedule. Until the next time, I will see you later. Thank you for joining us. Bye-bye now.
Bye, guys.
Bye. Thank you.